Joining me now is former U.S. Attorney General Eric Holder. He's the chair of the National Democratic Redistricting Committee, and his new book is Our Unfinished March, The Violent Past and Imperiled Future of the Vote, A History, a Crisis, a Plan. Welcome, General Holder.
It's good to see you, Andrea.
Good to see you again. So let's talk about this Supreme Court leaked draft. Yeah. How unprecedented, first of all, is the leak, and the way they came down in terms of breaking precedent, ignoring stare decisis, and deciding to completely overrule Roe v. Wade after 49 years?
Yeah, I think the leak is unprecedented, both in its breadth, its scope, in its completeness. You know, we've heard rumors before about where the court is going to go, how the justices perhaps were aligned, but never actually seen a draft opinion. And that's serious, and that's something that needs to be addressed. But what we really need to focus on is what's contained in that leaked opinion and where the court appears to be lining up. Looks like they're going to overturn Roe versus Wade, inconsistent with a notion that you adhere to precedent that people have relied on over the course of the last 50 years. It's an attack on the right to privacy. And so the question has to be asked, is it only going to be abortion that is going to be at risk, or is same-sex marriage going to be at risk? With regard to the regulation of contraception, is that going to be at risk? Even interracial marriage. All of these things are based on the right to privacy, which this opinion, in its form as we saw it, really goes at that right to privacy.
And if they care so little about precedent and overruling precedent, what about Brown v. Board of Education? What about other major civil rights rulings of the 60s?
Well, you know, essentially, that's a question that you might have said, well, you're going too far, Andrea. And yet, you think about those Trump judges who, when they were questioned about is Brown versus the Board of Education a super precedent or something that you would not re-examine, they waffled on that. And that always kind of struck me. I mean, how could you waffle on Brown versus the Board of Education, and yet they did? Now, I'm not saying they're going to reinstitute Plessy versus Ferguson and we're going to have a whole system of American racial apartheid again, but I think that shows a mindset that they're not going to adhere to the extent that they should to precedent. There's an ideological agenda here. It's almost as if they've been waiting for this moment to arrive. They've got a court now that is ideologically driven, lower courts that are ideologically filled. And the American people are going to have to watch over the course of the next 18 months or so. We're going to see courts, and especially the Supreme Court, deal with affirmative action, abortion, an important gun case. There's a remaining component of the 1965 Voting Rights Act. All of these things are at risk.
Well, the way Mitch McConnell engineered keeping the seat from President Obama and Merrick Garland, his nominee, has this court become so political that it is now as political as other parts of government?
Well, that's one of the things we talk about in, Our Unfinished March in the book. As I call it in the book, the theft of those two seats. I mean, you say Merrick Garland is not entitled to a hearing because he's not even interviews, because it's too close to an election, and then you put Amy Coney Barrett on the court while people are in the process of voting. So those two seats, I think, were stolen. You see the ideological nature of the court and the way in which they are ruling on a variety of things. And yeah, the court does not seem like the unconnected, distant, precedent-driven institution that has always garnered great amounts of respect. Of the three branches, it's always been the Supreme Court that has gotten the greatest amount of respect. And now you see polls, I guess about 40% of the American people now support the court, and 60% of the American people think that it is just like the other branches. And that's a serious negative for our society.
Should Clarence Thomas recuse himself from decisions affecting the 2020 election, given his wife Ginny's activism, her emails to Mark Meadows?
Yeah, clearly he should. I mean, that's not a close question. That is not a close question, given what we know about her involvement in the attempt to stop the peaceful transfer of power, the emails that we have seen, or the text messages that we have seen, and who knows what else the January 6th committee has. I don't think that, you drive decisions about recusal on the basis of appearance, not only reality. The appearance that gives is such a negative one that I think Justice Thomas just has to recuse himself.
Should the court should there be some oversight over the court in terms of ethics policy, since they have been self-regulated, the only branch of government that is? And in this case, at least you think that it's inappropriate.
I think the court in a whole bunch of ways needs to get into the 21st century. First, cameras in the courtroom. Why not? I mean, every other branch of government does that. It would not affect how people argue cases before the Supreme Court. The American people need to see how, they've gone to, during the course of the pandemic, the radio transmission of arguments, and I think that has gone fine. And yeah, an ethics code is certainly something that I think the Supreme Court justices should be subject to. They should not be self-regulating. They should be like every other Article III judge and subject to a code of ethics.
I want to talk to the January 6th events and the events around it. Now we hear reports from Politico that John Eastman, a lawyer advising the president, was calling the Pennsylvania lawmakers and asking them to retabulate the vote. This sounds very much like that Raffensperger call from President Trump. Find me 11,800 plus votes, the exact number needed. In both of these cases, is this illegal?
Well, I'd want to see more of the evidence, but it is certainly what we would call, when I was a prosecutor, there's certainly a predicate for us to believe that
enough to start investigating.
Exactly, to start an investigation. It's extremely disturbing to see what we already know about what Mr. Eastman did, what Jeffrey Clark did at the United States Department of Justice, what Mr. Meadows was doing from the White House. These are all things that I think obviously need to be investigated, and especially for those people who are lawyers. Even if there are not criminal sanctions, there need to be bar sanctions. And I think real questions asked about whether or not their ability to continue to practice law should be examined, because they did things inconsistent with what officers of the court are supposed to do.
I know you describe yourself as an institutionalist, and you come to this reluctantly. But talk to me about Donald Trump, that Raffensperger call, and other clear pieces of, allegations, if not evidence.
Yeah.
Tell me about whether you think he should be prosecuted.
Well, I certainly think we're at a place where a consideration of his prosecution is appropriate. And that's a hard thing for me to say. People need to understand that's a hard thing for me to say. The United States never does these kinds of things. As much as we disagree with the predecessor administration, you never do use the criminal laws to go after them. And yet, given the breadth of what it is they did, their aim, which was to stop the peaceful transition of power, which is a defining thing for American democracy, if you can prove that he was involved substantively, and if you can show that he had the requisite criminal intent, and it certainly looks like we're going in that direction, I think a consideration of his prosecution is appropriate.